Hi, everyone. A very warm welcome to you all. You will be welcomed a few more times before we get to our speaker, but I'm Professor Angela Daly. I'm jointly appointed here at the University of Dundee between the Leverhulme Research Centre for Forensic Science and Dundee Law School. And for want of a better term, I guess I'm going to be emceeing this evening. So hi to everyone in the room and hi to everyone online as well. So I'm going to this is the first, the inaugural Dundee Law School and Leverhulme Research Centre for Forensic Science lecture, and we're really pleased to have Dr Judith Townend to give this lecture. I'll introduce her in once others have said their welcomes, but it's really exciting to have this lecture series that I think we're aiming to have once a semester, and I guess probably hybrid as well, so here in Dundee and also online too, looking at topics that cross over law and forensic science, particularly around technologies in the legal system, use of expert evidence, and kind of other disciplinary interactions between law and forensic science. And really pleased to have Judith here as our inaugural speaker, and thanks very much for coming as well. This lecture today is, of course, supported by Dundee Law School and the Leverhulme Research Centre for Forensic Science, and also the Justice and Power research theme in the School of Humanities, Social Sciences and Law at the University of Dundee. So I'm going to ask the leads, the head of our law school, Professor Sarah Hendry, our Deputy Director of the Leverhulme Centre, Professor Anne Coxon, and also the lead of the research theme, Professor recently promoted, Professor Megan O'Neill, in turn to come and give a welcome from them before we get to the lecture. So I'd like to invite Professor Anne Coxon to come first.
Well, good evening, everyone. It is my pleasure to welcome you all, both those of you in the room and those online, to this first joint hosted lecture by the University of Dundee Law School and the Leverhulme Research Centre of Forensic Science. The Leverhulme Research Centre, or LRCFS as we call it, is a 10-year, £10 million project funded by the Leverhulme Trust. It's the largest interdisciplinary research team which is dedicated to improving the robustness and quality of the science that's presented to the civil and criminal courts as evidence. LRCFS extensively collaborates with a wide range of stakeholders from across the justice system, industry, academia, and a lot of other places to identify and address the scientific challenges that exist or are emerging in forensic science. This covers the investigation of crime, the subsequent analysis in court, the interpretation of the scientific results, and the communication of that to the court. Ensuring high quality and reliable science is not only delivered to the court, but communicated in a way that the trier of fact can understand it. That's the science, its limitations, and its significance within the context of the case or the question that's being asked is of great importance in ensuring safe justice decisions. Our work at the Centre is made all the richer for collaboration with the public through our broad and extensive public engagement programme, which is one of this lecture this evening is an example of one of those things that we do. I myself am very much looking forward to hearing Dr. Judith Townend speak about her research findings of justice system data and her proposals for an international research and policy agenda for technology and transparency of the justice systems. In a world where technology continues to evolve and reach further and further into our lives, this is a very important subject in protecting a fair justice system for all, and I hope that you all enjoy this inaugural lecture as much as I'm looking forward to it. Thank you.
Thank you. I'd now like to invite, thank you. I'd like to invite Professor Sarah Hendry, head of the law school here at Dundee, to give her welcome, please.
Thanks, Angela, and thanks, Judith, for being able to come all the way from Sussex to Dundee. It's a long way. And really nice to see people in the room on such a beautiful sunny evening, where I'm sure there were other things you might have wanted to do. I think from the point of view of me and the law school, and there's a number of lawyers in the audience, staff, students, Two reasons I think why this is particularly interesting. First of all, there's justice, which is of interest to all lawyers, whether you're a criminal lawyer or a family lawyer or human rights lawyer or an environmental lawyer. The deficits in justice and the barriers to justice are immense, and we're all painfully aware of that. And secondly, for a number of years, and working closely with Angela and the Leverhulme Centre, I have sought to develop with colleagues in Dundee to put Dundee Law School at the forefront of legal education in law and technology in the broadest sense. And that encompasses a lot of things. It includes IP law, it includes data regulations, Angela's specialism. It includes the use of tech in law firms, where I think undergraduates are often not well served by law schools. So there's a wide range, and then it includes digital evidence and everything to do with evidence in the courts. So I think there's a wide range of ways in which that nexus between law and technology is important to us, but important to the lawyers of the future, and some of them are here as well. And it's incumbent on law schools to make sure that they're properly prepared for the world of practice that they'll all be moving into. So both in terms of justice and in terms of law and technology, our work with the Leverhulme Centre, our shared chair with Angela, and it's really great to be having this inaugural lecture. And I see that Professor Giddens is in the audience. He's a research lead in law, and he's a theorist, a proper theorist. And the first thing he said when your name was mentioned was, that would be brilliant, she's really good. So I think your reputation spans across all sorts of areas of law, and we're really looking forward to hear what you might say tonight. Thank you.
Thank you. And last but not least, I'd like to ask Professor O'Neill to give her welcome as well. Thank you.
Thank you. And hello, everyone. I must admit, I'm feeling a little bit like little sibling who's tagged along to the party, but I'm delighted to be here and I'm delighted to welcome all of you. So I'm not from the law school or Leverhulme. So I'm Professor Megan O'Neill from the School of Humanities, Social Sciences and Law. I lead our research theme on justice and power within the school. So within Justice and Power, we're a multidisciplinary collective of researchers and scholars who are interested in themes around inequality, discrimination, social and environmental justice, criminal justice, and all aspects related to who has access to power and who controls power and shapes it in society. So I was delighted to be invited to help support Judith's visit today, and we're very much looking forward to hearing your presentation. Topics related to technologies in the criminal justice system are, of course, very much in line with our priorities within Justice and Power, with all the implications this brings in terms of access to justice and how that might relate to issues of inequality across the board. So thank you all for coming, and we're delighted to be here. Thank you.
Oh, actually, I have my own mic. Sorry, I keep forgetting that. So yeah, thank you very much, and really appreciate the support from different parts of the university for this event. So it's my great pleasure to welcome Judith and to give an introduction to her before her talk. So Dr. Judith Townend is Reader in Digital Society and Justice at the School of Law, Politics and Sociology at the University of Sussex. And she's also co-director of the Sussex Digital Humanities Lab, which for anyone who has worked in kind of digital humanities or even digital social sciences is a very well-known and renowned place with some really great people, as is the law school too at Sussex. So she's one of a number of really fantastic researchers doing really interesting work on an interdisciplinary basis, I guess looking at law, justice, media and communications, journalism as well. Judith's research looks at public access to information, the protection and regulation of public interest journalism, and also broader issues around freedom of expression. Her work is very interdisciplinary, using socio-legal methods and approaches from social sciences and humanities to understand legal and policy developments in these fields. The main reason why I invited, or I was very keen to invite Judith here, is because among her many publications in this area is a very new book, which I have here, called Observing Justice, Digital Transparency, Openness and Accountability in Criminal Courts, that she's co-written with her colleague Lucy Welsh. Now, the book is, I think, just came out earlier this year.
End of last year.
End of last year, okay. So end of 2023, and I think it's a really kind of interesting book based on the empirical research that you have done that maybe you're going to tell us a bit more about in terms of monitoring and accessing criminal courts in England as researchers or I guess members of the public, and engagements with the new technologies that are being used in courts, sometimes I guess to facilitate more openness, but not always being the case. And at least in the area that I work in, law and technology, we often hear a lot about kind of AI in the court system, AI judges, and so on. And there's a lot of media attention and also kind of discussions in our more professional outlets as well. But one thing that I think has been kind of understudied is actually the current uses of technology in court systems. In Scotland, for instance, the use of remote courts during the lockdowns, as well as kind of other, I don't know if can call it a bit more mundane arguably more mundane technologies that have been used in terms of new software, sometimes more successfully than not in parts of kind of our courts. And I think this book is really important because you really look at these issues in a very granular way and engage with, I suppose, broader notions and principles around openness and transparency, as well as kind of issues around data protection and privacy too, in how courts are kind of functioning these days and the sorts of technologies that actually have been implemented rather than those that speculatively may or may not be implemented at some point in the future. So I think this book is a really important contribution to the field, and I'm really excited to hear more about what you're going to tell us about your research. So a very warm welcome, and Judith is going to speak for about 40 minutes, and then
no more, I promise.
Okay, and then there'll be some time for questions and answers, and we're going to finish up by 6:30 for sure, so we can enjoy a bit of the evening and also maybe have some more informal conversations as well. So I'll
Thank you.
Give it over to you.
Thanks. Is my mic okay? Am I audible? Yeah, it's on. So. Okay, is that better?
No, sorry, better.
Better now. We should have checked this before, shouldn't we?
I think it's just in there.
Am I good?
Yeah.
Yes, okay. Wow, thank you very much. It's a real privilege to be here, and thank you very much for that very generous introduction. I was very glad to be invited, so thank you to that from the colleagues in the law school, as well as the Leverhulme Research Centre for Forensic Science. And it's a wonderful opportunity to visit Dundee because it's my first time to the city. So tonight's lecture will discuss the technology and transparency of courts and tribunals and the interaction with law and policy. And I hope it will resonate with some of the issues that you've been grappling with at the Centre for Forensic Science. And I'm excited to hopefully later learn a little more about the groundbreaking and important work underway in terms of how evidence and data is used in the criminal and civil courts and what the future might look like. The next test of the technology. No, we did test this earlier. Yeah, I can do it from there.
No, try now.
There we go. I thought I'd plug my book just in case Angela didn't. So I'm going to cover 4 areas tonight. First of all, if you'll indulge me, a little context as to how I arrived at these topics. Then I'll go into some insights from my research findings before turning to methods of civil society engagement for law and policy development in the area. And then finally, I'll have a go at proposing where we go from here. So in terms of the geographic and jurisdictional relevance, I need to give a big caveat to start with and say that I've mainly worked and researched in England and Wales, and I haven't, I know a little bit and heard anecdotes about what's happening in the Scottish courts, but I haven't done a detailed research project on Scotland. But I'll be very interested afterwards to discuss any differences and similarities and just please forgive me and feel free to correct me if I make some kind of generalisation about the UK that only applies to England and Wales, but I will try not to do that. So I'm going to start with the context. So Angela gave me that very lovely introduction, thank you. But I just wanted to mention another aspect of my professional background to help explain the perspective that I bring to this topic. And because also there's a relevance to what I've been told about the Dundee's 3 Js. A Scottish colleague quickly educated me about them last week when I said I was coming to Dundee. And the J that I'm interested in is, of course, journalism, rather than the jam or the jute. Before I became an academic researcher and lecturer, I was a journalist, and I had set my heart on good old-fashioned newspaper journalism. But I soon discovered that this industry was in a period of immense change at the time I was embarking on this career, as social media platforms, especially YouTube, Facebook, and then what was Twitter, took off in the early 2000s. And I realized that I seem to have a habit of picking professions that are reported as being in continual crisis. So although I jumped ship and I gradually slid back into universities, the area of journalism, and in particular what I would describe as public interest journalism, have remained research interests. And it was as a journalist that I first encountered this concept of open justice, the well-known principle that justice should not only be done, but it should be seen to be done. And at that point, I didn't dwell too much on either the legal and technical practicalities, nor the conceptual and philosophical issues. I was a fierce advocate of open justice, seeing it as an essential part of freedom of expression and fair justice, that the courts should be communicated clearly and openly, that the public should be able to witness court and tribunal proceedings, whether through the media or by their own attendance. And I thought, this is court transparency. And I read my relevant chapters of what they call the Bible for journalists on media law, McNay's Essential Law for Journalists. And I assumed that I would just have good access to the courts as a researcher as well as a journalist. And in some ways I did, in terms of accessing and watching court proceedings. I found lawyers immensely helpful and generous with their time. Access to that particular world was easier than I'd expected as an outsider to the legal profession. And I was impressed by courts such as the UK Supreme Court, which is pictured on the right of the slide, with its impressive building and decor and its online resources, which include press summaries and streamed hearings. But I soon realised that that was an outlier, the Supreme Court. This is not typically how open justice operates in the UK. But because of the Supreme Court's importance, it benefits from better resource communications and online support than the majority of our English and Welsh courts and tribunals. And also its age, it only opened in 2009, so it hadn't been hampered by ancient analogue systems in quite the same way. But in general, my experience of trying to track and observe courts was that I was meeting obstacles and I was hitting brick walls. I found it difficult to follow and track court hearings and cases, and I realised how disparate and inconsistent records and publicity was. Even where public documents were theoretically available, it was often practically difficult or even impossible to access them. And at the time of my PhD research, which was looking at defamation and privacy law, I felt often that it was like being shown a public filing cabinet and said, "Who got access to this?" But then realizing that there were no handles to the drawers or any labels on the drawers. So it actually frustrated any efforts to try and actually get into and access the contents. I also realized that published judgments and news reports really were the very tip of the iceberg in terms of what was happening in the justice system. And this became a core argument of my doctoral work, that we couldn't possibly understand the impact of defamation and privacy law on journalism when we had formal records and so very little on what was actually happening. We didn't know very much in terms of what was happening with pre-action threats and settlements outside courts. And even where we did have hearings and formal records of hearings, there wasn't always proper public records or publicly accessible records. So it was in fact impossible to make firm conclusions, although many did try and do that, on the precise impacts of these laws without a much deeper research that really tries to go beneath the surface. Now, around the same time, I realised that the justice system wasn't keeping up with the open government agenda, which at the time, so I'm talking about sort of the 2010 to 14 period, and that was really being heavily pushed by the Conservative Lib Dem coalition era government. And early on in my doctoral research, I made a submission to a government consultation on open data, urging them to look at the justice sector. But at the time, I just felt that justice data wasn't really getting a look in. Not very many people seemed to be interested. And I think that early neglect has really led to a lot of the systemic problems that endure well over 10 years on. And then a final sort of procedural block. I realised that though the common law principle of open justice is widely understood as being crucial to holding the justice system to account, it's interpreted very variously through different transparency mechanisms. And critically, this is a really important feature, is that the private actors are relied on to deliver many of the mechanisms for accessing information about the courts. And often there's very little consistency or oversight. And just to give one example, the way that private companies provide transcripts at very high costs. You may have seen in the news recently, David Davis MP drew attention to the fact that he'd been quoted something like £100,000 for access to the Lucy Letby trial transcripts. So because of these obstacles and these brick walls, I became increasingly interested in how open justice works in practice. And then from that, how has the introduction of new justice technologies such as video-enabled proceedings, fully remote court hearings, online conviction and dispute resolution procedures affected our public observation of the system? And then getting into some quite thorny territory, how should we balance privacy and rehabilitation related rights with the public's right to know about legal cases? That kind of hopefully just gives you a bit of context of how I got to where I was with the research I was doing. So those are the questions and tensions that preoccupied my research. Now, in terms of sharing some of the research findings, there's two aspects I want to discuss today. First, the management and processing of justice system data, and secondly, the adoption of digital technologies within the justice system. So to start with my research into the first of these, access to information and data from the justice system, underpinned by this principle that I've mentioned of open justice. And open justice is, I contend, our strongest protection and enabler of access to the courtroom, whether it's physical or virtual, and to court documents and to court's data. So although we may have rights to access to information in other areas, most obviously through human rights and Article 10 of the European Convention, and also in some ways via Article 6 relating to access to justice, it's this common law principle of open justice which has dominated legal arguments in this area of law. It provides a public right to observe and report court proceedings, and it's well entrenched at the heart of the rule of law. And it's often talked about as quite rigid and inflexible, defined by case law originating over 100 years ago, and with even much deeper roots in the classical and Middle Ages. But in reality, it exists through shifting social norms and technologies. And so although we have this mainstay of case law supporting its implementation, open justice is guided by a sometimes contradictory body of guidance and rules, and sometimes at the whimsical discretion of court staff, judges, legal professionals, and those private services that I mentioned. So Jeremy Bentham, the 18th and 19th century philosopher, is often quoted to explain the rationale for open courts. And I've got the quote on the slide there. So to quote, "Publicity is the very soul of justice. It's the keenest spur to exertion and the surest of all guards against improbity. It keeps the judge himself while trying under trial," which is pretty persuasive. And this open justice principle is very highly prominent in popular culture and news media, and yet we have this confusion in terms of how it's implemented. And that was identified by the House of Commons Justice Committee in its inquiry in 2021 to 2022. And they said that there was, to quote, "confusion over the precise definition of the principle and how it works in practice." We also see tensions between the different purposes of open justice, between shaming or in the area of whether it's got a shaming function, whether it's to deter, in terms of accountability, whether that operates at an individual level or a collective or system level accountability. And there are other perspectives to consider, such as the potential intrusion and stigmatization felt by direct participants in court proceedings because of this openness of court records. And my research has identified that the principle and practice of open justice has been overly focused on the interests of news media organisations. So while journalists play an essential role in delivering open justice, they are not the only conduits for sharing information with the public. The result of the narrow focus is that there are procedural and cultural barriers to observing justice in practice, and this undermines both the transparency and, by implication, the potential legitimacy of the criminal process. So I put transparency in the title of my talk, and I think it's important just to dig into that a bit in terms of what I mean by transparency. Over time, it's come to describe openness and the ability to view and access data. The former Canadian Chief Justice, Beverley McLachlin, has reminded us that open court proceedings existed long before transparency became a buzzword of governance. Transparency is perhaps now so ingrained in civil society and legal initiatives on democracy that we no longer recognise it as the metaphor that it is. So that's why I want to just pause and sort of dig into it and think a bit critically. But I use it to explain sharing information and events with the public. And obviously we need to be attuned to varying uses of the term and also alert to the fact that transparency initiatives may be restricted in some way and don't necessarily lead to information to all. So to extend the metaphor, the window is obscured or opaque. So I conceive transparency as related but broader than open justice. So in this way, open justice is part of achieving justice, transparency and accountability. And my work with Lucy Welsh, that's already been mentioned, adopts a more general model of accountability where openness and transparency are used to ensure that governments or other powerful institutions are answerable and held responsible for their decisions. And in the specific context here, open justice describes the application of provisions for openness and transparency in the justice system that ensures the judiciary, the executive, other decision-making actors are held to account for the way in which justice is delivered. But justice transparency may be even broader than what happens in the court, to encompass justice in society beyond the formal process of justice through courts and tribunals. And this might, for example, include stages of criminal or regulatory investigation. And here I think there's a connection to the work of the Centre for Forensic Science, or post-trial settings such as parole boards that have not always been subject to the open justice principle in the same way. So I've tried to present you with a very brief account of open justice and justice transparency, and now I'll turn to what I conceive or understand as justice system data. And by this I mean the information or data that's generated by the formal process of justice. A researcher, Natalie Byram, who used to be at the Legal Education Foundation, set out a table which another researcher, Cassandra Wiener, and I added to try and think about the different categories of data that exist within the justice system. And these include court user data, so that might include demographic or inequalities characteristics. Then we might have case level data in the court file, and that might include party names and outcomes of cases. Administrative data, the name of the allocated judge, the record of the charge or the claim. Judicial rulings, which would include judgments and sentencing remarks. And then the final category we have is hearings data, which would include transcripts and more audio and video recordings. Now, access to all of those categories of data in England and Wales and other common law countries has been patchy and inconsistent, with access to many data categories controlled by third-party actors who operate as justice system data gatekeepers in piecemeal arrangements that have often evolved quite erratically over decades of legal and judicial practice. And as I mentioned already, even where you've got that public access and you're permitted to access certain data, the practical arrangements for doing so may not be clear. So I spoke about my frustration when I felt that justice data wasn't really getting the attention it deserved, but I think it has got a little bit more attention more recent years, and I'm not alone in holding these concerns. In 2023, the House of Commons Committee on Public Accounts criticised a lack of data and research hindering evaluation of the impacts of the court's reform programme. And similar concerns were highlighted in a report by the Centre for Public Data in 2023, which exposed concerning gaps in the data gaps, in the criminal justice system. And the authors of that report define these data gaps as areas where a lack of official data means that questions of significant public interest cannot be answered. So here again, I think this is where we see an opacity of justice. Victims of crime, as well as those working on criminal appeals, are complaining about a lack of access to transcripts. I already mentioned the most recent complaint by David Davis. So the consequences of this poor data practice and availability should be worrying the government and the judiciary. As well as the concerns that I've already mentioned, absent or inaccurate data has implications for the development of AI-based and digital justice technology and tools, which not only stymies innovation, but it also affects the reliability of innovation such as predictive analytics and automated processes. So given this poor state of data in the UK, and obviously I've looked most closely at England and Wales, what can we learn from other countries? So in the spring of 2020, probably quite memorable to everyone in the room, I was commissioned by the Legal Education Foundation to undertake a study of 3 other common law countries to look at how they manage their justice system data. And actually the disruption of the pandemic was to my advantage because everyone was moving to Zoom, so I could quite easily access people in different countries. So we looked at Australia, Canada and Ireland. And the brief was that we were going to look at examples of good practice that would help us further the cause for better provision to access to justice system data in the UK. Now, although we did find examples of some good practice in terms of improving public access, we also discovered that despite some jurisdictional differences in how things were done, we had a lot of commonalities, and these countries too were encountering similar difficulties and tensions. We saw the same impact of legacy practices, underinvestment and a decentralized approach to technological reform, a data deficit for user and case experience, and this tension between privacy and transparency in the provision of court records that contain personal data. And overall, a lack of accountability and governance measures for the management of justice system data. And in fact, I was quite surprised when some of the people I was speaking to in these other countries were actually looking at the UK's justice innovation with envy and thinking that we were doing things quite well and advancing, which took me by surprise because I was part of a group of people who were constantly complaining. So I'll come back to where we go from all of this later. But first of all, I want to turn to this other area of focus that I've had, which is the adoption of court technologies and the impact on criminal justice in particular. So this slide sets out a few of the developments that we've seen in recent years and some of the major developments in the digital space. So up until 2010, we started to see technology for use of remote courts and remote participation developing, including special measures for vulnerable or intimidated witnesses, and a gradual expansion of that. 2010 to 2020, so despite evidence suggesting that it was not cost effective, plans to roll out a virtual court pilot across the system was announced in the 2010s. And although progress was slow, partly as a result of issues with funding and also issues around enabling the tech systems to join up. A very significant development in 2015, as part of further efficiency drives, a single justice procedure was introduced, which allowed a person suspected of committing a criminal offence to be summoned by post and enter a plea by filling a form either by post or online. And if there was no plea or guilty plea, then single justice would deal with the case in closed court. If not guilty, then the case would move to a traditional court setting for trial. Now, research by the charity Transform Justice in 2021 showed that about 2/3 of people hadn't responded to the notice. And most recently, we've seen the journalist Tristan Kirk's important reporting on single justice procedure reveal very concerning patterns and outcomes, especially for vulnerable individuals. And most recently, a ruling by the Chief Magistrate of England and Wales in test cases which concerned rail evasion offences that were dealt with under single justice procedure means that potentially a huge number of single justice procedure convictions, up to 75,000, could be deemed void. Moving beyond 2020, we start to see increasing digitalisation. A Crown Court order in 2020 made provision for the recording and broadcasting of judicial sentencing remarks in the Crown Courts. We saw a new initiative that enabled accredited academic researchers to access data sets and justice data sets. And then in 2020, prompted by the pandemic, courts across jurisdictions were required to very quickly adapt. And we saw at least 56 countries by mid-July 2020 adopting some form of remote court. And we had emergency legislation in England and Wales, which temporarily amended existing legislation to allow and increase the use of audio-visual equipment in court proceedings. So once that had happened, sort of stimulated by the impact of COVID, it then sort of allowed all of this to develop much faster than it maybe would have done otherwise. So the Police Crime Sentencing and Courts Act 2022 made it provision to expand the use of virtual courts and to expand the live streaming or access to virtual courts by interested parties. And taking digitalisation a step further, the Judicial Review and Courts Act 2022 provides for people to be convicted and sentenced entirely online. So where do we go next? What does the future hold in terms of these technological advances in the criminal courts? Overall, it seems likely that court processes will further transition online, especially as that becomes more normalised in legal culture. But it seems unlikely this is going to be accompanied by major financial investment, given the history of the court reform programme so far, which has run late and over budget. And the tenor of a consultation document on open justice published by the Ministry of Justice in 2023 suggested that they didn't envisage any expensive interventions in terms of public access. So in terms of how you observe and access courts proceedings when they are being enabled by technology and in these remote settings, as part of this research, we identified notable obstacles to physical and virtual courts and a lack of clarity about the borders of open justice in practice, policy and law. So in an observation project that we held in a magistrates court in 2020, in 7 out of 8 cases involving video links, there were complaints about or problems with the connection or the camera position causing frustration in court. Our student researchers described video link hearings as chaotic, involving significant waits for people to join the link and poor quality for audio and video, issues with hearing what was happening, the images on screen and locating people. And more recently, significant problems were documented by the charity Transform Justice in its London Court Watch project, focusing on magistrates' courts. So I question, despite the sort of bold claims of increased access, the extent to which participants can engage through digital developments and virtual courts, and the extent to which the public is enabled to observe such proceedings. And this applies to virtual or partially remote courts, to the single justice procedure that I've described, and also on automatic online conviction. And despite initiatives such as the broadcasting of sentencing remarks, we're not really seeing a transformation of access. Only a fraction of relevant cases have actually been broadcast in that way. And then, of course, we need to think about AI and in terms of its potential role and future adoption within the justice system. I can't really do this talk without addressing it. This is what I've described as the AI elephant in the courtroom with my AI generated images. So the question here then is, if AI decision making is introduced within the justice system, then what mechanisms will there be for observation, regulation and accountability? Now, use of AI is not outright prohibited. All we have so far is some quite short guidance for judges, and a recent speech by the Master of the Rolls left open the possibility of its future use. But of high pertinence here, I would say, looking back to these analog era examples so that we learn lessons from those around single justice procedure, for example, and a lack of transparency in magistrates' decisions. And we should learn from the mistakes that were made in terms of what can happen when there's insufficient public scrutiny of a judicial process. Which takes me to the next section of my talk, which concerns public involvement. How do we involve the public in the design and regulation of these new technologies? Well, before we were talking about the adoption of AI technologies in the justice system, I and many other people were advocating for increased public involvement in the development of policy and guidance on open justice and transparency practices. And partly this was driven by my frustrations as an outsider. How could those of us attempting to monitor the court system do so effectively? And as I transitioned from the role of journalist to the role of academic researcher, often working with civil society organisations, I wanted to make sure that academics and civil society organisations were in that conversation as well. But there's a practical question about how we involve civil society in this area of policy and lawmaking. And obviously, it's not a question that is limited to the justice sector. It's relevant to any area of technology in public life. And I've captured that update on X by Rachel Caldicott to illustrate it. So she drew attention to a roundtable that was being hosted by the new government on AI policy, questioning who was at the table. And this is a common complaint by those working in NGOs and civil society, that they aren't invited to participate in these discussions. But equally common is the criticism or response that we can't all fit in the room, like this isn't a practical thing to do. And that's in the response to Rachel's complaint, as you see on the screen there. So where does that leave us? Do we just accept the limits of the small table? And I would argue to all the cynics that we shouldn't. And I'm guided by Jenny Tennyson, who was former CEO of the Open Data Institute, and she's founded a newer organization called Connected by Data, which is campaigning to involve the public in technology and data policy and decision making. And I've been working with them for about a year, and I've learned a lot about public participatory methods and what does and doesn't work. And in responding to the debate that Rachel started there, Jenny offered some practical advice on what civil society participation could look like, as well as encouraging interaction with people with lived experience. And her argument is that early engagement makes things better and it reduces later criticism, among other arguments. So if we accept that, we accept that civil society should be involved, then what does that actually look like in the context of justice transparency and open justice? And this is where I think it links up to some of the things that I've already said around open justice. Most simply, it refers to the presence of people in the court as participants and observers. But as is frequently observed, although we lack reliable and comprehensive data, court attendance by the press and the public has diminished in the latter 20th and early 21st century. And I'll just give you a few insights from the little empirical data that we do have. As part of a study of magistrates' courts in Bristol, Phil Chamberlain and his colleagues found the public gallery to be generally empty, except for a few with a direct connection to the case. And they did quite an impressive court observation exercise where they looked at 240 cases in Bristol Magistrates Court in 1 week of 2018. And of those 240 cases, there were just 3 articles in the media. They just saw 1 journalist, and then they argue that was hundreds of stories, hundreds of potential stories left untold. In a separate project that we undertook at Sussex, we found something similar, although we looked at a much smaller set of cases. Timetabling wouldn't allow us to get to 240. But we looked at 43 cases over 5 days in March 2020. Only 1 was attended by media reporters. And I should say that's before the impact of the pandemic. In follow-up research in March 2022, no media presence was noted in the 40 cases observed over 8 days that our students attended court. So while the move to remote and virtual hearings in some contexts allows for the possibility of greater public observation, it's not yet clear whether this has happened. So we frequently hear senior judges saying that there is greater transparency because of this move, and we have had a few rare cases where we do have a good number of journalists and other observers viewing proceedings remotely, but observers are frequently reporting issues with accessing remote courts, and that includes sometimes actually accessing the information they need to be able to join the court hearing. There's not always good processes in place. And further, as I've already just talked about, data and documentation about court processes and cases is not always consistently available across jurisdictions. So all of this limits the opportunity for citizen participation, which I argue has a detrimental impact for access to justice. So Lucy Welsh and I in the book argue that public participation is essential as part of the accountability process, as part of a model or understanding of participatory accountability. And these are important because models of public participation and systems of governance operate to assist with accountability. And Welsh and I argue that open justice provides a way of facilitating participatory accountability in the justice system. And further still, we think that the public should take an active role in the design and the development of justice systems, including these processes of digitalisation and the introduction of new governance for uses of justice system data, importantly, including the application of the AI technologies that are on the horizon. And this reflects approaches that are advocated by civil society organisations such as Connected by Data. But until now, there's been insufficient attempt to fully engage the public in design and conduct of justice processes, and the mechanics of open justice have often felt overlooked, even when you're looking at something like a £1.3 billion programme of court reform. So in 2022, the Legal Education Foundation commissioned a report on public attitudes to uses and governance of justice system data, which was perhaps the first exercise of its kind. And the methodology for the report combined quantitative polling with a nationally representative survey and also public deliberation exercises. And it asked participants about sensitivity of court judgment data, how court judgments should be used and by whom, what participants felt was an acceptable use of court judgment data, and how access and governance can create a system that commands public trust. Now, tellingly, perhaps not surprisingly, among the findings was low awareness on public access to justice information, with 70% of the respondents answering that they knew not very much or nothing at all about the information that was contained in court records. People were often quite surprised about the level of detail that can be shared publicly. So that was a really encouraging initiative, that report and that research, which gave us a few more insights into what the public knew and thought. Another welcome initiative was the UK government's consultation on open justice in 2023, to which I and many other stakeholders made submissions. It hasn't yet reported. We've obviously seen a transition to a new government, so it's on my list to chase to find out if the findings will ever be published. That was prompted by an inquiry report by the Justice Committee that I've mentioned already in 2021 to 2022, which had been the first sort of exercise, and this consultation that followed was the first exercise to gather public views on open justice across jurisdictions in England and Wales. But we'll just have to wait to see what happens from that and if they do listen and whether those views are taken anywhere. So I talked to a lot of people in this area, and some people are very sceptical about the practical impact of such initiatives, but I remain ever optimistic, and I think it's encouraging that the UK government at that point was soliciting public views rather than solely relying on limited representative groups and sometimes these official views that have a detachment from what's actually happening on the ground. And in other countries, we've also seen good initiatives. The New South Wales Law Reform Commission undertook a report on open justice and court and tribunal information access, disclosure and publication. And there's interesting work in Canada around open government and justice, which include quite wide-ranging research. Another programme of work that I wanted to mention is the Open Government Partnership Programme, which some of you may have heard of, in which governments work with civil society groups to produce commitments to open governance and transparency in regular national action plans. Open justice has featured in previous action plans in the UK, but generally it's been a little neglected and overlooked. And more broadly, there's a concern that the UK government has not been giving as much resourcing, and there's been less interest in recent years in the open government agenda. So what I need to turn to now is, if the public are to be consulted and involved in this process, then what does that mean? And it could get a bit messy, because we might expect a difference of opinion about the shape and the nature of mechanisms that allow justice transparency. But I would say that's an essential and welcome part of the process. Now, some of the key tensions, which I've touched on already and were identified by Beverley McLachlan, the former Chief Justice of Canada, are privacy and security. And a question here is, should, as the court has often determined, open justice override such considerations? Individuals may suffer stigmatisation difficulties rehabilitating in society, especially with the ongoing publication of digital data. And so if you cast your minds back to where I started with Jeremy Bentham's quote on the soul of justice, in contrast to that, we could talk to people with lived experience of the courts and how publicity feels to them. And a criminal defendant that participated in some earlier research I did described how, I quote, "Publicity is a life sentence and it makes it very difficult for you to put it behind you and move on with your life and build a home and get on with everything when it's a click away from people." And I think it's essential to engage with those tensions, and we can't really ignore them. They're also an elephant in the room that we need to think about. Other issues that arise include concerns around judicial independence and effectiveness and the effect on public confidence in the justice system. And that's reported to be a factor in the French government's introduction in 2020 of a law to prevent the public from engaging in judicial analytic activity, including using information from public sources, that's reported decisions, to identify patterns in and make predictions for individual judicial behaviour. So far, the UK courts haven't gone down that path, but it was an interesting one to watch. So what could be the consequence of further civic engagement in justice system design? It may be that this wider public group are more hesitant about the publicity of proceedings and the distribution of justice system data than those in control. So when the Legal Education Foundation commissioned that research by Ipsos on public attitudes, they also commissioned an evaluation by Connected by Data to look at the effectiveness of the research. And that evaluation evidenced institutional hesitancy or nervousness about public participation in justice data governance design. So where does all of this leave us in terms of public involvement in this area? So the previous government was not inclined to set up any kind of stakeholder group looking at courts access and transparency, despite a number of us continually pushing for this. The Court Service has an engagement group for the traditional media, which it feels is sufficient for the time being. But in lieu of an official group, a number of us have formed our own informal network to try and draw attention to issues, which we've called the Courts and Tribunals Observers Network. And its membership, it includes academics, journalists, and civil society representatives. Earlier this year, we expressed our dismay when court guidance on public attendance and observation was inaccurate in places in terms of how it presented public rights to be in court. And there's been a slight tweak and remedy to that, but our concerns remain about many aspects of guidance and practice. But there has been some progress. Earlier this year, the Lady Chief Justice announced the creation of a new panel for open justice and transparency, which will be chaired by Mr. Justice Nicklin. And although the membership is confined to the judiciary and the judicial office with an observer from the Ministry of Justice, they have also created a stakeholder committee. Initially, that seemed to be targeted at journalists and the media, but on a number of us checking and seeing if they would also like other people to be involved, they did update the call, and they've made it clear that a broader group of observers is welcome to attend. Now, I wasn't able to go to the first meeting, but I've heard some positive comments about that first meeting, and it obviously remains to be seen whether that stakeholder group will be convened again. But it feels to me like a step in the right direction. So again, I'm optimistic, although I'm aware that it may have limited scope and ability to address certain issues as sort of a judiciary activity rather than coming from government. And that doesn't sort of let the government off the hook, I don't think. It's critical that the new government builds good mechanisms for civil society engagement and participation, learning from organisations such as Connected by Data. So now I move to my final, and I promise you slightly shorter, concluding section. Where do we put all of this? And I would suggest that we need to think big and we need to think cross-jurisdictionally. Although it can sometimes feel like there's only a small group of justice data obsessives who are worried about all of this, sharing their complaints via social media, I can continue that we need to argue that the management and availability of justice system data and the development of justice system technologies are not getting the attention they deserve. And we need an international research agenda to address the impacts of insufficient justice system data and the importance of public involvement in the design and the rollout of justice system technologies. And the good news is that some of this is already happening. In recent months, we're seeing some really important work getting funded. So we've got emerging work on digital justice user experience. We've just seen new EU funding announced for a project on the digital implications of virtual trials by an academic called Lisa Flower, based in Sweden. There's the ESRC's Digital Good programme of work. And in Latin America, there's a movement around open justice and transparency with an acronym of RIHA, which I learnt about. I was fortunate to be invited to Mexico City last year to hear about a programme of work that was being developed by the Mexican Electoral Tribunal of the Federal Judiciary on transparency and rule of law. And speakers at that event from around Latin America were sharing their experiences. And I was really encouraged by all that was happening there and hope that we could take something from it. We're also seeing the development of court observation projects. So I've mentioned a few times the charity Transform Justice. They developed this big court observation project involving volunteers focusing on courts in London. The Bureau of Investigative Journalism has also undertaken court observation work. And then we're seeing a broader set of work by civil society organisations that are interested in technology, human rights and the law. So the research agenda is developing. So I suggest and hope that this international research and policy agenda for the technology and transparency of justice systems would also be relevant to the Scottish courts. And this would prioritise improving the quality, availability and governance of justice system data. It would pay attention to jurisdictional specificities in practice as well as law. And it would seek opportunities for public engagement in law and policy making on open justice and justice system technologies, which include these AI-based tools. And I argue it should include a principled approach to open justice, which includes but looks beyond news media organisations for that informational transparency. And it encourages, or at least better understands and tolerates, accountability through public participation in the court process as part of this participatory accountability that I've described. It won't be easy and it's probably going to be a bit messy, and I can understand why people do have reservations about public involvement, but I think it's essential. And it could, to give some examples, include court observation initiatives, improved public legal education resources and training, and involvement of members of the public in justice system data governance design. Now, these projects, I argue, should try and think about some of the tensions that I've alluded to today, to minimise unnecessary stigmatisation and intrusion on individuals and think quite carefully and deeply about uses of personal data. I'm afraid I don't have the answers, but I think we need to talk about it. I talked earlier about the central principle that guides common law approaches to open justice, that justice must be seen to be done. And it continues to be obviously relevant and of utmost importance, but inevitably its application and core purposes need to be revisited to reflect changes in society, changes in the ways in which people share information and ideas. And that's the challenge for all of us that work on these topics, whether we're part of academia, civil society, or for those that are in the judiciary or government. And I think that global exchange of experiences and information about open justice and public participation methodologies is vital to meeting that challenge effectively, fairly, and intelligently, and in a research-informed way. So that's what I have prepared, and I'm very much looking forward to hearing your thoughts in our discussion. I've got some key references at the very end, and I'm sure there's going to be a way to share the slides if you're interested. And you can find me online very easily as well if you want to follow up afterwards. So thank you.
Thank you very much. That was fantastic. What I suggest, because I think we've got quite a lot of people online, or we did anyway. What I would suggest is that we maybe take a couple of questions from the room and then see if people have questions online. So does anyone have any questions or comments in the room for Judith? Yes. Oh, sorry. You need to wait for the microphone. Yes, I forgot to say that. So yeah, please wait for the microphone to come to you.
Thank you. This just reminded me of something that by chance I'd been reading a couple of weeks ago. It was a Guardian article about, it was an interview with some of the last court reporters at the Old Bailey. You're familiar with it. I recommend it to anyone. If you look up chortle, chortle, scribble, scribble, the right article should manifest. But that it tied in with this about how the only way that these sort of independent reporters could make money is if they reported on salacious stuff that they could sell to newspapers. So the normal gang murders didn't get reported on. It had to be something like, what do you call it, a middle-aged white woman murdering a man. That would be unusual enough to sell, to make, as they put it. So that's basically the problem we're at in terms of access to justice to the public. Is there a solution to that? And also the availability of things, you put it, it's like there's more books than ever in a library, but there's fewer librarians to parse it for the layperson, if that's a fair analogy. Again, are there any solutions to these problems, or this kind of inevitability? Thank you.
Yeah, I think yes. And does anyone have another question in the room, and we can set you up? Well, this is okay. So yeah, answer, and then the microphone will go to Tom, and then he'll ask a question.
I'll answer this.
Yeah.
Yeah, I read that piece as well, and I second the recommendation for reading it. It's a fabulous, rich, colourful piece, sort of giving you a real insight into the culture of court reporting. Like these reporters have specialised, especially in the Old Bailey, and why they're motivated to do it. And I think that piece actually really captures this idea of how the traditional media has shaped what we understand by court reporting and public access, but it's only, for me, a part of the story. I go around and around because I'm really interested in the work that journalists do, but there's a very specific agenda there that I would say misses some aspects of a broader public interest, and also a ducking away from those tensions that I've been talking about with privacy and transparency, because of course journalists that are interested in the more salacious detail or telling certain kinds of stories don't want any minimization of personal details, because it would undermine the kind of reporting that they want to do. So balancing that is really tricky. I'm really good at identifying problems, but not so good at coming up with the solutions. I mean, but I just think in the design of open justice policies in terms of the guidance, that's why talking to this broader set of people is really important, as well as these very seasoned, well-experienced journalists. And on the second point, the second problem, remind me, was the navigation. And I think that's another major challenge, and that's where I think public legal education is really important, so that you're actually thinking about, well, who resources the giving of information to the public in ways that makes it possible to navigate it. And looking at this Transform Justice's London Court Watch project, they've just produced a new document sort of explaining how they undertook the project and some of the challenges. And some of their observers were just completely overwhelmed by the prospect of attending court, and then when going into a courtroom and not being able to understand what was happening in the room. So there needed to be a big education piece of work there to make that possible. So I think that's very much part of it, but resourcing is obviously a big challenge.
Thanks.
Hi, Judith. Thank you. Really, really interesting talk. So you talked briefly about the kind of split between the kind of responsibility of government to do something about the kind of technological changes in court management and data and so on, and then the kind of things that the kind of judges themselves are kind of doing, talking around those problems. And I wondered if you had any further thoughts about the kind of that split and the kind of respective responsibilities for the courts and judges and the judiciary, and potentially barristers and things as well, versus the government. Because I've been looking at some of these similar issues in a more kind of historical context. And so with the birth of law reporting, for example, kind of formalized law reporting, that was something which government kind of refused to do anything about. And there were similar problems of poor quality data, too many law reports that were kind of disagreeing with each other. And so it was the legal profession, the barristers, that got together and put law reports in place, because the government kind of didn't really see it as their responsibility. So I wondered if there was any kind of similar parallels or anything, any thoughts you had about that kind of split responsibility.
Thank you. That's a great observation and point. I mean, I think the justice system is sort of unique in terms of the actors that are involved in these different interests, and which has led to this sometimes feels crazy situation of how all this different data is managed by all these different parties with no one really taking the overall responsibility in ways that hasn't quite happened in other areas of public data. So I've often tried to look at other sectors to try and learn lessons or understand what's happening. But if you look at health, for example, there are some similar issues, but it's just, yeah, it's not comparable in some ways, which is why the justice system needs a very particular project and piece of work, I think. And I think, yeah, I mean, sometimes it's just extraordinary, the arrangements that have come to be, and people just taking it upon themselves to have their own initiative to open up case law or to, you know, the publishing of the law reports. But there has to be that willingness from these private actors to do it. So it might be that they're going to make money out of it, is obviously one big incentive, or they may have some kind of altruistic vision, like with the case of Bailey, for example. It was, you know, a groundbreaking in terms of making case law available to a much bigger audience. But I think we're just seeing this mess as you try to work through it with executive and judiciary, which is why I think there needs to be some kind of overarching exercise that involves all of them focusing on transparency and open justice, not just bundled in with the other technology projects that are going on. It needs its own specific project. So although I'm really excited about the fact that judiciary did set up something and set up a stakeholder committee, the fact that it's sort of detached from court service and MOJ worries me slightly, I think.
Thanks. I think we'll see if there's any questions online. No, okay, any questions online. Okay, Matthew, sorry, Matthew up there.
Hi, thank you for the talk, really interesting. The thing that leaps out to me, especially if we're talking in the context of digitization, is that while there was a lot of talk about, you know, the public side of it, if we're going into the digitization context, then we potentially also look at the private sector coming in there in various ways, which has a very different understanding of things like openness and justice in particular. Like, admittedly, it's a very different jurisdiction, but what immediately leaps to mind was the Loomis case in America, where a private company's AI was used, or algorithmic decision-making system was used in a criminal trial, and because that was a private system, there was no ability to look at how it made that decision. So how does the private sector work in the UK in this context then?
Yeah, I didn't specifically talk about where law tech fits into this, but I think, I mean, that has been a driver, that you've got these legal innovation companies that want to start doing exciting things, and they've been very frustrated about the limits with access to data, which is a limited development of some tools. And obviously is an important part of it, but I would argue there needs to be good governance and oversight. So there was a governance panel set up. I don't know much detail about how it's operating in practice or not, but that was supposed to be grappling with these issues and thinking about how private actors would use data that they're getting from these official sources. But I think, because, like, relating to the previous question, often these bits of data exist in places like entirely outside the official control of the judiciary or government, and therefore private companies will come in and use that data and do things with it, but it could have big consequences. But I think just a huge amount more investment needs to be done to probably impossible to keep ahead of it, but to be thinking very seriously about dangers in the area.
Any more questions in the room or comments in the room? All right, shall we go for the one online, and then we'll go to Tristan?
So the online question is, do you think that the recent riots might have helped progress this agenda somehow, given the vacuum that there seems to be between the public's knowledge of naming individuals, public interest, etc.? Do you think we need to start including more decision making or statements to educate the general public in general TV and journalist reporting?
Yeah, I think in an era of misinformation and in terms of the far right activity, for example, that having accurate and reliable information that can be shared about what is actually happening is really important. But I know that people, more, cynics would say, well, that's not really going to do anything necessarily. But I don't think that can be a reason for not having accurate data in the public domain that can be used to fact check and to challenge narratives. I think that is really important. A slightly uncomfortable part of this is thinking about whether courts data could be used maliciously or in malign ways by different sorts of actors with a certain purpose. So many of you may have followed or know about the contempt proceedings around Tommy Robinson filming outside a court. And although obviously there were sanctions in that example, it's where there are uncomfortable things around how open justice may be used or manipulated by people with a far right agenda. So I think there's lots of interesting questions around that. I mean, a more positive thing relating to the riots was that there was then a great deal of media interest with the response, the prosecutions, for example. And so we saw quite a lot of court reporting around those very fast prosecutions that happened after the violence.
Thanks. We'll go to Tristan. The microphone is just coming to you.
Hi there. Hi, Judith. I really enjoyed the talk. One thing that came to mind, obviously I've got a slightly different lens because I'm a computer scientist, but one thing that came to mind is that this sounds a lot like the debates around open data just in general in the late noughties. Certainly privacy, transparency, data being a mess, all those kinds of things. And so I was wondering if, sorry, my question's a bit unformed. First of all, I was wondering whether any of those, any of the people involved in those discussions are involved in these discussions now. So things like the Open Data Institute and things like that. But one of the wins for open data, I believe, is that it was really easy to demonstrate, the benefits of opening things up. There were lots of potential new businesses or applications or public services that could be created with this. So I was wondering what people, you said that there were some outliers that were more open than others. Have people been doing interesting things with the data from those? And then I guess this leads on, also connected to open data, one way of bootstrapping a lot of these things before people gave us access to data was to exploit information rights. So FOI, data protection rights, anything like that. Is it possible to do that with these courts? Can you use information rights to get stuff out when you showed a picture of a brick wall? Is that one way of traversing the wall? Sorry for so many.
There's quite a lot in there. I'll do my best. Let's start with the last point. FOIs of limited use, because Section 32 of the Freedom of Information Act makes an exemption for court records, so you can't use it to access court records. So that could have been a completely different story if during the drafting of that legislation a different decision had been taken. So there may be other ways that FOI could be used to get at some kind of justice system data, but not the court records as such. But I've recently restarted a conversation with Maurice Frankel from the Freedom of Information campaign, and I'm hoping to do a bit more work on that. And the same with data protection. I think increasingly people are trying to use data protection as a route to accessing personal information that may be contained in court records, and I think it's a mixed picture so far, but I don't have a definitive answer. It's a research project that needs to be done. The judiciary were pretty slow on data protection stuff, and still if you go on the English and Welsh judiciary pages and look for data protection information, it's quite limited. There's a panel and then there's a kind of brief annual report. It amazes me that there's very little activity given all the potential issues that could be happening, and I just wonder if not everything is being captured or recorded. And then in terms of, you're probably right that I am just harping back to some of these earlier conversations, and I think lessons probably could be learned from what people have done in other sectors on public data. So and even though justice sector has these particular characteristics, we should be looking to what's been achieved in other areas. So the Open Government Partnership does have a specific programme on justice, and the UK gets a slight mention in that, I think. I mentioned that Latin American movement that are interested in that, so that is connecting the open data conversations with it. But I think justice does have some very particular tricky issues around on the privacy stuff, because it is personal data that makes up these records. if that makes sense, or is accepted as being in the public domain, but is then becomes something different when you open it up in different formats. If that, yeah, I don't think it answers the question necessarily. But
do we have any questions online? Right.
Hi. Thank you so much for your amazing report and speech. I really was impressed of this, being a lawyer myself, obviously coming from a different family, from Ukrainian law system. I'm still working on the PhD, first year student with Angela Daly, and being in the context of AI and talking about the biases, transparency, and let's say working on those current and future challenges. You mentioned that there are lack of transparency, there is lack of public engagement. But if we are talking about the future development of the digital part of justice and the engagement, incorporation of AI into the justice, how we can avoid biases if, for example, there is like, because I think that, or I believe that the private sector, will be involved in constructing some kind of like language models or AI algorithm for this justice, right? So take into account that the private sector will be involved into something that will help the public sector, how to avoid bias, how to make sure there will be transparency, take into account that there is limited access and limited amount of records of those cases, like whether this won't be a huge problem or will be, and how to overcome or avoid it as kind of in a big scope. Thank you.
Question. I mean, that's such a great problem and question to pose, and would be a fantastic research project, and people should, if they're not already, be working on that, I think, because, and again, learning lessons from other sectors as well that can be applied to the justice system in terms of what transparency and algorithmic transparency can achieve, because it's a huge challenge ahead. And as I mentioned, we only have this very short guidance for judges at the moment on AI uses, so there's going to need to be a lot more work done in terms of thinking and anticipating the biases of the system, in terms of understanding the information that is feeding new technologies. So I certainly don't have the answer, and I haven't done a focus project on this yet, apart from saying in quite a broad way, this is a problem and we need to be talking about it, but we can't just put our heads in the sand and ignore it.
Do you think like the solution will be in a collaboration between the experts in all the fields, so technicians from their side, and let's say legal developers from the AI side, and you as one of the representatives of this transparency, journalist access, public access? Do you see like this is the, let's say, solution, because there is now a solid legal framework, nor for the AI nor for the future collaboration between those two sectors, whether the collaboration is the solution? Thank you.
I mean, I would always argue, as you will have got from the talk, that civil society actors and academics should be involved throughout as sort of critics, or maybe the annoying people in the room asking difficult questions. And that applies to any area of technology innovation, not just in the justice sector. But we see these events where certain critical voices aren't included because they're difficult and they don't fit a certain agenda. But I think if government are working with tech companies to develop new innovations, whether that's related to justice or other areas, then you need to also be thinking about governance and oversight and hearing critical responses to the uses of these technologies as well.
Do we have any online questions? Okay, does anyone have a question, maybe one or maybe maximum two final questions or comments? You can make a comment, you don't have to ask a question. Well, I think maybe we should finish it and just say thank you very much again to Judith for a fantastic talk, which has provoked quite a lot of interest and questions, and plenty more that I think we could talk about. So I would just like to thank you very much again, and I'd like to I hope you join me in thanking Judith.